Injustice anywhere is a threat to justice everywhere. Martin Luther King, Jr. What does King mean by this quote? Take a moment now and evaluate this quote. What does it mean to you? What do you think he meant? Today we're going to be viewing crimes against the justice system. These are crimes that could be committed either in a court of law or anytime you're dealing with a government agency. Whether it's a small agency like your local police station or even the FBI, CIA, or IRS, just to name a few. The first type of crime against the justice system is known as contempt of court. Courts have the power to cite any person in their courtroom for contempt when the person shows disrespect, disrupts the courtroom, or fails to follow a court order. These are not limited to the witnesses on the stand, but could also include lawyers as well, or as anyone who might be sitting in the pews to observe the case. There are two different kinds of contempt. It could either be a civil contempt or a criminal contempt. Let's take a look at what the differences are between these two different types. In civil contempt, a person could get fined or held in jail until they comply with the court order. So, for instance, if the court orders a party to pay alimony to their ex-wife or ex-husband, or turn over evidence, and the person refuses, then they could get fined or held in jail until they comply. Generally speaking, when people are jailed for civil contempt, they usually agree to comply with the court order. But not always. Criminal contempt. The purpose of criminal contempt is to punish those who disrupt or attack the integrity of the courts. Federal courts, of course, have the power to punish by fine, imprisonment, or both, if any one of the following are true: misbehavior of the person in its presence, or so near to as to obstruct the administration of justice, misbehavior of any of its officers in their official transactions, and disobedience or resistance to its lawful writ, process, order, rule, decree, or command. For more examples of criminal contempt, check out pages 21 and 22 in your textbook. The next type of contempt that we're going to look at is perjury. Perjury is committed on the witness stand by whomever is testifying. It's when the person lies under oath. Sometimes they're doing it to protect another party. Now, in order for perjury to be applicable, the person that's testifying on this witness stand must willingly make statements that they believe or that they know are untrue. Next, we have subordination of perjury. This is when someone else convinces another person to perjure themselves and that person complies. So, as an example, Peter asked Judith to lie under oath. Judy lies about Peter's whereabouts on the stand. Peter is guilty of subordination because he convinced Judy to lie for him, and Judy completed it. According to the False Statements Act passed in 1934, it's a crime to lie to the FBI and certain representatives of other government agencies, even if you never made an oath. Perjury laws and the False Statement Act require that the falsehood be material to influence or sway the outcome of a case. So, in other words, lying about your age wouldn't matter because it doesn't change the jury's opinion. Next, we have witness tampering. This is when physical force or threat of physical force prevent a witness from getting on the stand. So, if Kendall is an eyewitness to a murder and is going to testify against the alleged murderer in court, Kendall has been cooperating with the investigator and in the meantime has been receiving anonymous phone calls and letters threatening her if she testifies. The anonymous caller, as well as whomever wrote the letters, has committed witness tampering. Another form of tampering is jury tampering. This is when the attorneys specifically cite evidence on their behalf to sway or persuade the jury, thinking otherwise, but it doesn't happen during the trial. Jury tampering happens, say, when a juror goes to the bathroom and maybe the attorney follows, or the attorney stops the jury on their way to lunch, or discusses something with their client openly in the courthouse with an earshot of the jury for the jury to hear. These are all considered jury tampering. Next, we have obstruction of justice. Obstruction of justice is any interference with the orderly administration of law and justice. In order for obstruction to apply, the following must be established. 1. Judicial proceedings is pending, meaning there's a court date and the court has not yet started. The trial has not yet been started. Secondly, the defendant knows about the upcoming proceedings. And thirdly, the defendant acted in such a way intending to corruptly influence or impede the proceedings. In other words, the person was looking to somehow change the outcome of the trial. Next, we have bribery. Bribery occurs when a person gives something of value, such as gifts or money, to public officials, with the intent of influencing such officials. In order to establish bribery, the government must prove that the person offering the bribe intended to influence an official action, regardless of whether or not the person accepts the bribe. Now, in regards to obstruction, one example is when One example would be jury tampering or witness tampering, stealing court records, influencing, obstructing, or impeding investigations. So in other words, many of the crimes that we discussed in this chapter previously. Please notice that obstruction does not mean that the person has to be successful in their obstruction. And in regards to bribery, the government does not have to prove that the official accepted the bribe. So, for instance, if someone walks up to the New Jersey senator and asks him to vote a certain way on a bill that's coming up in Congress and says, "I'll give you $1,000 to vote this way," many states will then turn around and have a separate charge for someone who offers the bribe versus the corrupt official that accepts the bribe. Now, since we have now discussed various forms of crimes against the judicial system, take a look at page 26. On the class activity called Section 1001, we are dealing with a criminal code, which is a federal code. This federal crime of lying to federal officials is the newest and most controversial of all the crimes against the judicial system. Unlike perjury, this crime does not require that the person made the statement under oath. On page 26, you'll find an example of the statute. You're going to take that statute and apply it to the three cases, Brogan, Turner, and Yermian. Again, the copy of the law is on page 26. Please make sure you read that prior to going over each portion of the cases provided to you. Be sure to use the graphic organizer that was provided on Schoology and submit it when you're done.